So this is what we're going to talk about, is a very emerging set of laws and issues and problems. So I know what some of you are probably thinking. You're all creatives. You've come here to see what's the latest in VR, to talk with each other, trade information, be with your peeps, and generally probably have a few beverages. So why was the lawyer invited? Well, I was invited to try to keep you all out of trouble. I'm not here to be a buzzkill. I'm not here to, give doomsday prophecies in a monotone or throw ice water on all the innovative, fantastic stuff you're doing. My goal here, and the reason I'm here, is to keep your buzz going. I'm here to sustain it by keeping you out of trouble. You don't want to get in the crosshairs of a government agency or sued while those agencies and lawyers are trying to figure out how the law works in this space. You want that face. So I know about this because I was a barrister for a long time, about 20 years, and then I escaped and I became a litigator, a transactional lawyer. But it's all good because it taught me what can go wrong with creating content and monetizing it and ways to prevent it. It's kind of like the advent of the internet, which I was around for, from a legal and regulatory standpoint. And real simply, legal and regulatory can't keep up with how fast VR and AR and MR are changing and are infiltrating pretty much every industry on the face of the earth. So there's no legal certainty, really, but what I'm going to do is point out some areas of concern. I'm going to talk about some guidelines and make some suggestions on how to protect yourself. So there's some precedent on all this from games and social media and online content, so we're not totally flying blind. Oops, sorry. So my purpose here is so you can keep making magic, keep exploring, keep innovating, keep creating the amazing stuff you're doing without having to be delayed or spend a lot of money on problems that are avoidable. Okay, so here's sort of the big question. Should real-world laws apply to virtual and augmented ones if there are real-world implications? Well, the more immersive the technology, the better, but the more blurred between reality and virtuality, the more problems. But there is one thing we do know. The way to avoid a lot of the problems is to deal with the legal issues and regulatory issues at the beginning. Have a qualified lawyer, knowledgeable lawyer, vet what you're doing along the way so problems can be avoided, and so that if there are problems, they can be easily remedied so that they don't grow into big or really, really big problems. All right, so I see the look on some of your faces. Lawyers are always trying to get their hands in your pockets early, but that's not the case here, and I'll tell you why. Show of hands. How many of you have been involved in content where there's problems with the rights or IP? Couple. All right, how many of you have ever sued or been sued over content or IP? All right, so for the rest of you, the reason that's an important question is because it's 10 times more expensive on average, and this has been a researched and it's a known point, to hire a lawyer to prevent the problem from happening, or God forbid you get sued and to defend against that lawsuit, than preventing it from happening in the first place. That's a face you don't want to have. So this is especially true with startups. And the biggest problem with startups is who owns the IP. And very, very, very frequently, almost all the time, it's not legislated at the beginning. The way it should be handled is there should be contracts, there should be paperwork between everybody involved in the creative process, legislating who owns what, and there should be usually an entity formed so that this valuable, new, innovative IP is held in a way that protects everybody and makes that ownership situation clearer. But why does this happen? Well, as you all probably know, startups start up informally. There's informal collaboration, ideas are exchanged, there's trust, there's congeniality, people sit around. They talk about ideas, they vet them, the ideas morph. Some of these people stick around for the entire process. Some of these people leave. And if ownership isn't sorted out at the beginning, there's a huge chance that the initiative, the project, the iteration is going to be doomed from the beginning. And the reason for that is there's no way to know who owns what. There have been huge lawsuits with Snap and with Facebook that have just been about that have taken years and have eaten up 7 figures worth of money. So, at least in the US and in several other countries, if a bunch of people are sitting around creating content, and there's no paperwork, there's nothing legislating who owns it, everybody who participated in the creation of it owns an undivided, equal interest in it. And if you own an interest in copyright, you can kind of do whatever you want with it. You can license all of it to other people. You usually don't have to ask your collaborators. I mean, heck, you can license it to a competitor or a potential competitor. Legislating that ownership also gives the company and the content more value and prevents these kind of situations from happening. Two of the other problems with not legislating who owns what, one of them is prior contracts. Usually people involved in a startup have day jobs. And being creatives, it would be mostly jobs where you're in the process or part of the process of creating something. A lot of those contracts, be they employment or independent contractor agreements, say that anything you create during the term of that agreement is owned by either your employer or the company you're contracting with. So whatever you create as part of the startup, even if you try to legislate who owns it, you may not own it at all. So that's something that's very, very important when people start collaborating on something, be it a startup or not, is figuring out if there's going to be these sorts of problems. And the other one's extortion. There's 4 collaborators, 4 owners. 3 of them want to sell the company or want to sell the IP, and the 4th one doesn't. He can hold the other 3 up for ransom. He can demand more money or more ownership interest. So all of this can be avoided by that early legislation. When I say legislation, I mean by getting this all sorted out at the beginning and keeping your eye on the ball as it goes along. Okay, I'm going to talk about some specifics. The first one is legal, specifically rated VR, starting with games. There's becoming a huge problem with sexual harassment. It kind of is moving over from just plain online content, multiplayer games and whatever, but because VR is so immersive, a lot of women have reported that sexual harassment and unwanted touching in a VR environment, their avatar, is just as traumatic as were it real. IP is an issue because there's really no strong laws that govern this. And IP is everything from avatars, wearing or using brands or copyrighted material to just those things being embedded in the content itself. And then the newest thing is theft. Virtual currency, virtual goods have value. There was a guy, 2013, that hacked into people's RuneScape accounts, stole their virtual merchandise, and then sold it for real money on fan sites. So he got arrested, and he got sued, but he didn't get sued for theft. He got sued for hacking because all he stole was something virtual. And it was purchased with points or with levels or with virtual currency. Had it been purchased with real currency, it might have been a different issue. All right, as you know, there are platforms now where you can turn virtual currency into real currency and back again. So that sort of cryptocurrency model is drawing a lot of regulators in. So that's something that's got to be watched because they want to regulate it like Bitcoin, basically, even though it's unique to a platform or some content. All right, copyright in VR. I mean, you can create amazing stuff with light, with color, with sound. You can walk through it. You can spin it around. You can do all kinds of things you can't do with physical content. But copyright is basically governs who owns works, who owns creative endeavor. And in order to do that, in order to own it, it's got to be in what's called a tangible medium of expression. So online, content online is tangible, so you can copyright, content that's just online. But what about this? Is it tangible? Does it live someplace? Does it actually exist? If someone takes it and alters it or copies it, can you do anything about it? Not yet. I've heard this talked about several times here, but health's a big issue. Vertigo, seizures from strobe, nausea, dizziness, disorientation. This will obviously change as the technology gets better, but there have been lawsuits over this. But all of these things where I'm telling you, oh, this is bad, this is bad, this is bad, they're not that bad. And there'll be a takeaway after I finish with this game. The well, not with this, let me go back. Okay, so the takeaway from all of this is pretty simple. The way you protect yourself is have very, very robust terms of use, terms of service, and privacy policies. Make sure it legislates in there who owns what can be used by whom, and in what ways, so it's clear that, who's responsible for what also. You should lay liability off, if you can, on the participants clearly. And if you do that, it can protect a lot of this, because if you have a problem, you can say, wait, I'm not responsible. They weren't supposed to, post other people's intellectual property online. He wasn't supposed to do something with a participant-created piece of IP and change it around, which is copyright infringement. So let's talk about AR legal. Pokemon Go is obviously the poster child. So some of the things that's happened and has gotten Nintendo sued are trespass, nuisance, which are sort of related, and geolocation issues. Not to mention physical injuries, because you can't see the car coming that's about to wipe this guy out. So the geolocation thing is something that came up recently for anybody that uses, well, in this context, some people don't want players, running after Pikachu on their front lawns. So they have no way of doing this until recently, where there should be, and I guess Nintendo's going to implement, some sort of opt-out protocol where you'll be able to not be geolocated in the game, and therefore you won't have these problems. But this is all stuff that didn't exist, obviously, before VR and AR, that we're all sort of trying to figure out as we go. So the takeaway there, as I said, it's good, strong disclaimers, and there should be, for these guys, if you do something like this, opt-out if you're creating content, AR content, where people are running around in the real world but aren't staying in public places. All right, this is big. This is big online. This is big everywhere. And it's going to be bigger here because of the vast amount of data that's captured especially by VR. Not only do they gather, store, process a lot of data, but their geolocation makes Pokemon's look like it's not on, theirs is on steroids compared to Pokemon. So all that information, again, privacy information is protected in the US, both on a state level, local level, and a federal level. And a lot of countries do that. So there's a lot of laws that overlay it, but it's something that if what you're doing is going to collect a lot of data, has those sorts of issues. It also has some other issues, one of which is that geolocation again. How is it used? How of all the data, how is that used? Let me back up a step. So if data is being captured, let's say about a user's reaction time, that could be an indication of a health problem. If it discovers that he's visited a cancer clinic or that she's gone to an AIDS clinic, that could be a violation of health laws. Is facial recognition possibly a privacy issue if you haven't affirmatively agreed to it. And can the discovery of all this personal information lead to figuring out the identity of the real person? It can also lead to real-world crimes. The kind of information being gathered is, if the information being gathered is where you work, where you live, how you worship, what your political or sexual orientation is, a lot can be done with that. And it's important to know that recently in the US, geolocation information has come under the general privacy laws for online content, and it has to be handled very, very carefully, or else you could get into a lot of trouble. Also, it can facilitate real-world crimes. If people, sketchy people, know where you live, it can result in all kinds of horrible things like trespass, assault, battery, sexual harassment. So that's why that's becoming a big issue. And the way to mitigate against that, the takeaway, is to make sure that the information gathering techniques are compliant with all applicable laws, local, provincial, federal, and that, again, your terms of use privacy policies are very clear about, again, how's the data used, who can use it, can third parties get access to it, can other game players get access to it if you're in a shared environment, can they use your data? Is it clear whether they can or they can't? They said I could go over a little bit. Take 1 more minute. Okay. So I'll do this really quick. And I'm around, so if anybody wants more meat on the bone, just find me. So liability, there's so many people involved. When something bad happens, who's liable? So again, you want clear, accurate privacy policies in terms of use. You want affirmative consent to how data is used. You just don't put it in terms of use and then kind of use it the way it says. That's not enough anymore. You should allow the participants whose data is being used a lot of control over it, to correct it, to opt out of it, to prevent it from being used, and very strong data security. So it falls into two categories: real world rights in a virtual world and virtual rights in the real world, but I don't have time to talk about it, unfortunately. And these are the other legal issues that come up, all of which obviously have some meat on the bone. So all of this in summary is pretty simple stuff. Don't leave the legal for last. Have clear terms of use, terms of service, privacy policies so that everybody involved, you, the participants, the ISP in essence, you disclaim responsibility, you disclaim warranties, you have choice of law, you have a lot of control by the participant over their data. Be careful with copyrights and brands. Make sure you have those rights. If they were granted to you even a couple of years ago, it may not apply to virtual reality or augmented reality. And have really, really strong data security. Thanks. Going.